Michał Araszkiewicz from the Jagiellonian University of Krakow, and the title of his presentation is Conceptual Structures in Legal Reasoning, where Heuresis meets Justification.
Good afternoon. I would like to express my gratitude to the organizers for creating this wonderful event and for making it possible for me to deliver this presentation. I'm also grateful for making it possible to get acquainted with the work and persona of late Professor Jarkic, whose ideas I find most interesting. This very presentation is not in the spirit of deontologic thinking, but it moves us a little bit towards like the empirical investigation and cognitive science approach. So to begin with, we begin with the distinction between heuresis and justification in reasoning. I believe that this distinction is very well known. So heuresis is the sphere in which we are interested in the process of forming of hypotheses, of propositions in general, and the conclusions of some reasoning processes, while in the sphere of justification, we are interested in defining the relations between premises and conclusion in terms of reasons. Now, it is well known that the relation between these two spheres is complicated, to say the least. And for any lawyer, it is obvious that sometimes the conclusions are actually generated on a different basis than what is communicated in argumentative discourse as justification. Justification may be analyzed from different angles. So we distinguish internal justification when we are interested in the validity of the applied schemes of reasoning. The core of this investigation is the investigation of the relation of logical consequence. However, it can be also accounted for in a broader manner, so we can check whether any predefined scheme of reasoning is applied properly. This may be some informal logic step, an argumentation scheme, or something Alexander Pechennik would refer to as jump or transformation. External justification is focused on the status of premises, which are used as reasons in the reasoning process. And here again, the paradigm for this is this true functional status, so true or false. However, in legal reasoning, we often also deal with different types of statuses, like probable, proven, reasonable, and so on and so forth. The philosophical scientific distinction between the context of discovery and the context of justification, as discussed by Hans Reichenbach and Karl Popper, is a cognate topic, although this analogy is not too proximate, so one should be careful with its automatic application in the field of legal reasoning. So the relation between heuresis and justification might be investigated from different angles, and depending on what theory of heuresis in particular we adopt, this relation will be accounted for in a different manner. The process of justification is, generally speaking, more straightforward in the sense that we assume that justification has to be communicated in language, in symbolic language which carries meaning. So it is somewhat less problematic. However, heuresis may be analyzed on different levels, and if it's analyzed on this lowest level, neuropsychological or even simply neural on the level of investigated by the biochemistry of our brains. And of course, we are speaking about the completely distinct spheres of investigation, because there appears to be a dichotomy between these low-level processes and whatever can be communicated in symbolic language. However, we also have a higher level heuresis theories. So here is where the theories of fast systems in mind enter into the playground, but also even on a higher level, different types of reasons which are not considered to be genuinely justificatory reasons. So if we are discussing higher level theories of heuresis, then justification appears to be solely something like post-operationalization. So in fact, the decisions and legal decisions in particular are based on emotions, political convictions, subjective preferences. There are also famous experiments which show the correlation between the physical state of the judge and the severity of the decision. So justification is only what is manifested because it's required by the institutional system. And of course, it's an old story. It's not something that cognitive scientists discovered 20 years ago. It's been debated for a long time, especially within the field of legal realism. However, it seems that this view, according to which the actual reasons for legal decisions are completely distinct from what is communicated in justificatory discourse, are a little bit unrealistic, paradoxically, because it would be like a very inconvenient, unprobable predicament to try to abstract from the reasons we are taught to use during our legal education and training in the process of our decision making. There are also numerous experiments which show that the lawyers actually are triggered and inspired by the conceptual apparatus. So what is actually interesting and realistic at the same time are the relations between higher level theories which interact with the theories of legal justification, and this presentation concerns one of these theories. So we are interested in the cognitive scientific account of concepts. There are of course numerous scientists who are working on this type of approach towards investigation of the human mind. One of whom is Paul Haggard, the author of many books on how mind works, especially books on analogy and conceptual change. So here, concepts are understood as mental objects, which enable, in particular, the categorization of reality and inference. These representations, that according to which to this theory we have in our minds, are subject to computational operations. By computation, here we mean symbolic transitions. So we substitute one set of symbols by another set of symbols. This is not the arithmetic understanding of computational operations. And these operations are used to explain intelligent behavior of subjects. However, we have more than one account of the structure of concepts in cognitive science. And of course, this presentation is very rudimentary in this respect. So we have, as another, of course, classical categories, according to which a concept may be represented as a conjunction of necessary and sufficient conditions. We have theories of prototypes and exemplars, according to which we have a certain space of similarities, and the particular objects are classified or not, or are classified as being the member of a category to a certain extent, taken into account the similarity to the prototype. Prototype is a set of model features, so to say, or to an exemplar, which is an object embodying the model features. We have also more complex entities. This is the so-called theory of concepts, according to which concepts are in fact the sets of propositional entities that are used in order to make predictions and produce explanations. And finally, we have pluralistic use, according to which, in fact, we have different concept structures. Sometimes the contention that we have this plurality of thinking about the conceptual structures leads scholars to the abandonment of the very concept of a concept, because it's like too diverse. We also may investigate the internal structure of concepts, and here the frame-based account has proven to be particularly influential. So here a concept may be understood as a set of slots which represent the features of objects as certain values of the predefined parameters. These values are assumed from the predefined ranges. So, for instance, if we would want to characterize the concept of a horse in this respect, we may first try to fill in the slot of subtype of, and this is important because it already indicates the relation between one concept to another concept. It's a very specific type of slot. So, horse is a living thing, it's an animal, and it's also a one-toothed hoofed mammal. The size of a horse is from 14 to 16 hands on average. A hand is 4 inches. This is what I learned while preparing this presentation. So something new. And of course, it's the height of a horse in withers. And the characteristic sound the horses make is neighing. And of course, we might discuss whether these slots are sufficient to characterize a horse or not. But as noted before, it's not necessary for us to treat any of these parameters as sufficient conditions for concept application. A more natural approach towards this particular concept of a horse would be perhaps a prototypical approach. So we use this frame to characterize a range of prototypical horses rather than all horses. So the relation of subtype of indicated us that concepts are related to one another through certain relations. And here we have the part of classification of provisions, which is being developed in the field of AI and law. So here we have this relation of being a subclass of To generalize it, we might have kind of or part of relations. The other difficult to define associative links between concepts, inheritance relations, which enable us to infer that objects which belongs to one category will have the features because it also belongs to another category, and feature comparison along these predefined ranges of values. So as noted, this is not only considered within the cognitive science, but also in artificial intelligence, when we are building computational ontologies, that is the systems of concepts which may be used by artificial reasoners, like in this example. So some interim points for this moment. It is a mainstream view in cognitive science that humans possess and make use of concepts in the performance of tasks which are referred to as intelligent ones, such as decision-making, planning, learning, explaining, but also justification if we are involved in the process of producing justificatory argumentation. We also make use of concepts. It is, of course, important that the concept should enable a certain type of inference, and the fact that this inference is enabled by the concept should be acknowledged or recognized in the relevant communication community as the justificatory reason. So here we may recall this old discussion concerning the spheres of heuresis and justification, where it was noted that in fact legal decisions are based on a certain type of reasoning, for instance, political or moral reasoning, but legal justification has to be produced anyway, because subjective political convictions are not recognized by the community as genuine justificatory reasons. So, having said all that, let us consider how these conceptual structures view enables us to have some fresh look on the motorious vehicle in the park example. Perhaps the most debated example in legal theory. So we have a rule according to which the vehicles are banned from the public park, they cannot enter it, and we have a problem because we are considering whether an ambulance or a toy car or an electric kick scooter may enter the park or not, a wheelchair. And there are numerous other examples, such as the monument tank and so on and so forth. So, to keep this very long story short, the basic funding of Herbert Hart was the contention that legal concepts, they have this semantic core and semantic penumbra. So there are borderline cases, and we ought to so the judiciary have to do something with it. And there are, of course, different answers to this question. One of the answers to this question is discretionary decision making, but of course, this answer is not satisfactory for many scholars. So a lot of ideas have been coined to deal with similar matters. So we have this rules and principles theory developed by different scholars in different traditions, and they point out that to the idea of balancing of reasons, so that we have no straightforward rule-based reasoning here, but we have to do some comparison of reasons, and very often these reasons are found to be the values that back the legal norms. The concept of divisibility has been introduced at some point to legal discourse, which points out to the possibility of existence of exceptions which are not considered beforehand, so that they are in a way discovered due the process of the problem solving and allowing or disallowing this exception if we agree to conceptualize this as an exception, because there are different options possible. Depends again on the balancing or comparison of reasons. Well, sometimes even if an object is within the core of a given category, it seems that the conclusion following from this finding that the object is within the core of a category seems unacceptable for, again, certain reasons. And here we can also be tempted to make use of this divisibility theory. Huge theories of interpretations were developed through the centuries of evolution of legal cultures, and they can also provide some hints as to how deal with such matters. And especially in Anglo-American legal culture, we have this so-called big theories of legal interpretation, such as textualism, purposivism, or intentionalism. But we can also choose another path. And apparently, this path is very germane or proximate to what we can actually find in the rationales of judicial opinions. Of course, not directly. So, the answer to the question whether a given object identified in a real or a hypothetical case should be classified as an instance of a category, for example, vehicle, depends on the conceptual structure through which this category is represented in the first place. The lawyers are almost always tempted to define the set of sufficient and necessary conditions for the sake of classification, well, unless they are already informed that they are dealing with the so-called open concept. Then we say, all right, it's to be decided on the case-by-case basis on the balance of reasons. But the actual picture is, of course, much more complicated. So first, we have to determine what conceptual structure is being used to represent a concept which is expressed by language. Then we can focus on whether the structure should be modified in any respect. Concepts as mental objects do not come to us directly from legal sources. They are being developed in the process of our of the development of a human being, even before the legal training starts. But then these structures are being subject to modifications during legal education and training, and then legal practice. Or being involved in legal academia. The process of modification of the conceptual structures is iterative, so it's something like a never-ending process. And it is reflected in the evolution of case law. So if a lot of case law is easily available, then typically we have the phenomenon of complexity reduction in legal reasoning, and in particular in predicting legal decisions. if it's not easily available or poor quality, then the degree of uncertainty of legal decision making is broader. So we may imagine that vehicle is accounted for as a classical category through the set of necessary and sufficient conditions. Then, by means of necessity, everything falling outside this predefined set will be classified as a non-vehicle, and it will be allowed to enter the public park, provided that no other norms are applicable to the situation, but we stick to this original scenario. It's completely unrealistic, but it makes things clear. But even in this situation, the conclusion may appear unacceptable. So the focus may be switched to the interpretation of the conditions. So we can easily imagine that one of the conditions of classifying something as a vehicle is that this object is equipped with an engine. But engine doesn't have to be defined. So we may play with the interpretation of the term engine, which in turn may be interpreted as a classical category, but not necessarily so. And this is a very frequent situation, especially if we have legal definitions in statute law. The legal definitions do not solve problems, but they transform problems of type A into problems of type B. So into the problem of interpretation of definitions. The set of conditions may be subject to change. So we may still understand the vehicle as a classical category, but we can add some new condition, or we can make an exception to one of the conditions. This is also the path the lawyers tend to like to go along. But we can also remain faithful to the established understanding of this concept as a classical condition, but we can make a change in our conceptual net in a different region thereof. So, for instance, we may investigate the concept of legal norm we are using, and we may discover that the concept of legal norm is not a unified one, and that we have at least two types of norms, legal rules and legal principles, and that legal principles can do something with our decision making, even though we classify this particular object as a vehicle or non-vehicle. Sometimes we can go even higher and play around with the concept of law we are proposing. So, for instance, if the adopted conclusion is not acceptable on moral grounds, then, for instance, we can assume that the very concept of law we are adopting should raise claim to correctness, Alexei, which in turn may lead to the change of the decision, even though the classificatory reasoning is straightforward. Ambulance is a vehicle, but still we should allow to enter because it's justified on the ground of the values. But also the very conceptual structure which is used may be subject to change, especially along the evolution of the case law, and this is of course this is typically a very implicit process, but this process is reflected in the wording of the rationale of judicial decisions. Here we have a real-life example, namely, we have investigated the understanding of the notion of representation cost under the Polish corporate tax regulation. This is a very important concept because it has a bearing on the fact whether a particular expense will be subject to taxation or not. The concept itself is not defined in statute. It is only mentioned that it includes the cost of food and beverage. So there were thousands of legal disputes concerning, for instance, questions such as whether all costs of food and beverage incurred by the company should be included in the category of representation costs, or should any costs incurred to the benefit of the third party, like the potential client, should be included in the representation costs, and so on and so forth. It was also debatable whether, if any of these conditions is applicable, should they be treated as strict conditions, or rather weak links, like factors that should be taken into account, considered, but not necessarily like implying any strict conclusions. So finally, we obtained an answer from the Supreme Administrative Court, enlarged chamber, according to which there is only one sufficient and necessary condition. In order to classify an expense as the representation costs, the main purpose of this cost bearing should be the image building by the company. So this is, of course, quite an open standard, but on the other hand, it's very determined in the sense that this is the only condition you should take into account. And whether a given cost is borne for the main purpose of image building has to be determined on a case-by-case basis. And this is a very, so in fact, we are landing here perhaps in the area of theory of concept, because we need to understand the relations on the market, what types of expenses are actually considered by the relevant actors as image building, what type of expenses make sense for the purpose of image building. This is, of course, a dynamic standard. So one type of costs may be classified as an image building one in the year 2010, but not necessarily in 2020. And this has very important implications, because according to the Supreme Administrative Court, you can't make this standard more strict. So you can't fix any necessary or sufficient conditions which would imply that some expense has been borne for the main purpose of image building. This has to be like reflected anew on case-by-case basis. Okay, so to sum up, we may state that different conceptual structures this isn't working. So different conceptual structures both allow and constrain, like disallow, certain inference or argumentation powers in legal reasoning. Legal concepts are both ontological categories and inferential links. However, these categories does not have to be classical categories. They may be vague, they may be distributed, they also may be contextually dependent. There are different formalisms that may be used to account for these categories than the classical set theory, like for instance, fuzzy set theories or rough set theories or formal concepts. And this approach also can be usefully applied to show that legal reasoning, although generally divisible, may be locally indivisible. So it is possible to create such legal arguments which in particular legal domain will be practically undefeated. And this is particularly important for the sake of the use of classical categories. So if we have a well-established line of cases according to which there is a set of sufficient and necessary conditions for the application of a given category, then you perhaps as a practitioner of law, you can't actually effectively question this contention, that this particular category should be interpreted along the conditions A, B, C, and D. But you can still focus on the interpretation of these conditions. So there are certain ways, but they may be very limited. All right. So thank you very much for your attention.